The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. We want to welcome everyone to the Fourth Circuit Court of Appeals this morning, to the Tweed Courtroom for three interesting cases with an array of good lawyers. And in the first case, United States versus Beeman, we got Mr. Dinkin, appointed counsel.
Yes.
And you've been appointed counsel in the case since the beginning, I think.
I tried the case.
Yes.
Mr.
Yes. So you have the floor.
Thank you.
Come forward and say your piece.
May it please the court. My name is William Dinkin, and I represent the appellant, Brock Beeman. Mr. Beeman was convicted by a jury of sending 3 threatening letters in different prosecution that was in Norfolk, federal prosecution. 2 of the letters went to the prosecutor, 1 went to the case agent. We have raised 3 issues on appeal.
It was tried in Norfolk by Richmond judge.
Correct, Judge Young. The first issue is we contend that the district court erred in admitting a 4th uncharged letter that was sent about 4 months after the last charged conduct. And in this letter, Mr. Beeman included multiple threats to a number of other individuals, including the presiding judge, the court personnel, the U.S. Marshals, probation officer, just to name a few.
Well, you already got 3 letters in.
Right.
They're pretty bad.
They're terrible. There's no question
Absolutely
about
terrible.
that.
So what's going to make that fourth one not just prejudicial, but unfairly prejudicial?
Because he's added so many additional individuals to that letter. So the first 3 letters are directed primarily at the prosecutor in 2 of them, and the case agent in the other. Although we would agree that he also included a separate case agent in, I think it was one of the letters. But in this last letter, Mr. Beeman has,
The last letter, you mean the 4th letter?
correct, the 4th uncharged letter.
Right.
Mr. Beeman has now expanded the universe of who he is threatening. And it was our contention that,
Said he's gonna blow up the courthouse, didn't he?
right, at some point, it becomes, we
Think they're
contended,
piling on?
hyperbolic and
You
piling.
thought they were piling on?
Well, it was hard to pile
And
on.
you objected, and
Yes.
you preserved it, and the judge overruled you and said, it comes in under race gesti or 404B?
Correct, and we objected to both of those, on both grounds. So as far as res gestae, of course, those res gestae would include evidence that's intrinsic to the case rather than extrinsic, which is addressed under Rule 404B. And we contend that the evidence was not intrinsic to the case.
And all this is reviewed for abuse of discretion.
That's correct. It's an evidentiary decision.
And we've said this 404B evidence kind of thing is pretty much inclusive.
Right, it's a rule of inclusion,
Rule of inclusion.
correct.
Is that an opinion of, originally by my friend Judge Niemeyer, I think?
I've seen it so many times.
But anyway,
It seems to
but
be-
that term, I remember those words.
Right.
I might have
sure-
been on one of them.
I'm sure I heard it from Mr. Panth as well when we were.
So what do you mean by it's not intrinsic? It had
What's that?
some details in it that followed up from the first 3 letters in terms of how that plan might be carried out, didn't it?
Marginally, and that's what the judge essentially ruled. the trial judge held that it was intrinsic in the sense that it was either part of the same set of transactions is one way it can be intrinsic, or it has to be necessary to complete the story. And Judge Locke held that the fourth letter was necessary to complete the story because it showed some additional explanation of animus by Mr. Beeman towards the case agent. That additional animus was marginal at best. It explained that she had driven 700 miles to arrest him. Why not drive another 30 miles? That was the additional fact, which perhaps provides a little bit of marginal explanation. But what the court didn't address is the fact that we now have threats against the trial judge. We've got threats against the probation officer, the U.S. Marshals, just to name a few. And those are extrinsic facts. That's extrinsic to the case. And I think that the United States versus Brizuela case,
You're saying that the fourth letter was just too much,
it is too much. And Brizuela talks about piling on. It's a
piling on.
piling, right. But, as far as the analysis, Brizuela is interesting because it stakes out kind of two poles as to what's intrinsic. And on the one hand, they discuss the United States versus Kennedy case, which was a conspiracy case. And in Kennedy, the government sought to introduce evidence outside the charged conspiracy of the defendant distributing drugs. And there was an argument that that was extrinsic, not intrinsic. And this court ruled in Kennedy that it was necessary to complete the story because it showed who the suppliers were. And that kind of makes sense in a conspiracy where a supply has to come from somewhere else. And then in Brizuela, there's a discussion of the United States versus McBride case, and that's the other pole. And in McBride, there was a single drug transaction about a year before the charged transaction involving unrelated parties. And those two really stood alone. And this court found that was extrinsic. It wasn't part of the same series of transactions, and it wasn't necessary to complete the story. Brizuela falls right in between and really emphasizes the fact that it is a fact-intensive decision that this court has to make.
Under 404B, some can come in for prove a motive and identity and
Oh, sure.
pattern and all that kind of stuff.
Right, and that's,
there's a big list.
yeah, there's a big list. And
That's where the rule of inclusion we have in this circuit.
That's right. And that's a separate analysis from the res geste.
Well, it's a separate analysis,
Right.
but they were arguing it was admissible under
Under both.
both.
Right, and I'm,
If it's admissible under either one, it's admissible.
right, and so, taking them in turn, I just want to, if I could,
I mean, even if we were agree with you on the res geste,
right. Oh, then we'll
we
turn,
might disagree with you on the 404B, and that wouldn't help you any.
that would leave me right where I am. But we also take the position that it's not admissible under 404B.
Okay?
And,
Back to the Brizuela
sure,
case, that was one of the opioid sort of mill, that's probably, be careful with my, language about how you describe those, but one of the doctor's office
Right.
that were accused of, over-prescribing opioids.
correct.
And as I recall, that the evidence there was about specific patients who were not charged.
Right.
So there was details about separate events, separate patients.
Right.
I mean, I get this, your argument that there's some similarity here because you got a letter that wasn't charged and you got references, but at least it's somewhat different in that the evidence that you say was improperly admitted does contain information about the same threats or the threats to the same people.
Right.
So that,
I'll address that.
Yeah,
Because my case, that fourth uncharged letter, we could call it a hybrid letter.
Right.
Because it does reference the case agent, and it does have additional threats to the case agent. And if that letter, that fourth uncharged letter, was a threat directed just to the case agent and was expanding on the story regarding the case agent, then yes, I would say that would be both part of the same series of transactions and necessary to complete the story. And what the trial court really didn't address, and what I'm asking this court to take into consideration, is that Mr. Beeman in that last letter expands the number of the people. And
But
so
wouldn't it be more like Brazuela if you didn't have any reference to the victims that were charged and you just had threats to new people like
Right.
that we don't have here? That would fall, it seems to me, more squarely in the Brazuela world.
Right, I would be on all fours with Brazuela if that were the case.
Yeah.
My
So you
contention-
admit,
I'm on threes,
well,
not fours.
we could,
Right.
you're on something.
I'm on, right, but it's, the question is, and then really, it also turns on a 403 analysis, because now we've got a judge, the trial judge, being threatened. We've got the court personnel. So now it really comes right into the courtroom where these jurors are going to be sitting, and these threats are being made. And I think that there's a real risk of prejudice at that point.
There's no question there's prejudice of this letter. As Judge Wynn said, I mean, the government wouldn't have put it in if they didn't think it was prejudicial to you.
Right.
It's got to be unfairly prejudicial.
Right, and
You know, all good evidence is prejudicial.
right,
To the-
I
I mean, if it's supportive of the prosecution, it's prejudicial to the defendant.
they
If he
flooded us.
confesses, that's very prejudicial. That, I mean, that,
They flooded us with prejudicial evidence.
You did it.
Mr. Beeman put his name on the letters. So, you know,
I mean, you didn't make up these facts, you just got stuck with it, or you got stuck with it.
Well, I
You were brought into it by the court, because
Yes.
you're an officer of the court, and it's
that,
part of the work that lawyers do.
that's correct.
And you're to be commended for that,
Oh,
as a
well,
matter
thank
of
you.
fact.
If I could address the 404B, because you raised it and I want to at least touch on it. This court has a
I mean, I thought a 404B argument was stronger than that, but my instinct was,
right,
on behalf of the government, then if I was the government
Mm-hmm.
prosecutor, I'd have been arguing 404B ahead of res gesta.
right.
And am I right that this fourth letter was written after the indictment was returned?
No, I don't think it was. It was before the indictment.
They could have put that in the indictment itself.
So when you say, there was the Norfolk indictment, and it was after, there was a superseding indictment in Norfolk, and then this letter came, the fourth letter.
That's what I mean.
Yes.
He was indicted and then the letter came. It was post-indictment.
Correct.
They also could have gone back and added, they could have got another superseding indictment and put it in.
Well, the second,
Then they wouldn't have had to face the.
right, they could have added this. They didn't.
Yeah, then we wouldn't have this 404B.
Right, we wouldn't have this issue. But, so.
So they gave you an issue. They gave you,
They
they gave you
did.
an issue to,
Well, they couldn't really,
Bring up
they
here.
could have put it in, but it would have, I mean, wasn't it intercepted? So, I mean,
It was intercepted,
Yeah,
so it never
so-
made it to the,
never made it to the
but at that point,
targets.
everyone was on notice and they were waiting for more letters.
Right.
So as far as the 404B, if I could maybe quickly address that. So under United States versus Hall,
now you haven't gotten to either whether your, two other issues you raised here.
I have not.
That's- I
And
think
I'm
that's
happy
our
to-
fault.
I'll be happy to talk all morning,
Well,
but,
no, I just wanted to let you know.
Oh, I know.
We're not interested in being here all morning.
okay, no.
In this case.
So the 404B, there are 4 prongs, and first the evidence, and you're right, it's a rule of inclusion as to motive, intent, lack of mistake, all the things that are listed in the rule, but there's still another 4 factors that need to be considered before it comes in. And first is the evidence has to be relevant to an issue, such as an element of the offense. And in this case, the threats to the additional threats to the judge, to everybody that's not charged, those are not relevant to proving anything. Not as to the threat to the case agent or the prosecutor. those are really, and you want to talk about gratuitous and piling on, they're not relevant. It has no bearing on proving.
What was the nature of your objection to this letter? Did you, maybe you've indicated there were parts of it that would be admissible if that
Right.
was all in it, and there were parts not. Did you just object to the exclusion of the entire letter, or did you ask, well, can you redact those parts?
I swung for the fence, Judge. I moved to preclude the entire letter.
Was the letter such that you could maybe white out the names of the judges and all the others that are involved in?
We could have gotten there. We didn't have oral argument on this, and we briefed it.
I'm talking about the nature of your objection. I mean, could
Right.
you have done this?
I could have. You're right. I could have specifically asked the court to just black out those names and left the case agent in. But,
And
you know,
that would have satisfied the problem that you are now complaining
I
about.
don't think so. Our position still is that the threat, the
Well, I know
additional
you still,
information.
as Judge King alluded to, you still say it's prejudicial and it's
Correct.
bad, but it is. But
But
you look at
and
those first
unfairly.
3 letters, and you admit it, they were horrible letters.
Right.
And then you got details here that sort of lay out the plans, and there's a connectivity to it. Been looking at Rule 404B for decades now, and I can tell you that the road you're traveling on that, from what I have seen, is an uphill battle.
I recognize that.
I figured you did.
But nonetheless, and under the 4 hall prongs, the other material, the other persons who were threatened, that was unfairly prejudicial, and that's really where we're going with this. I see that I've got a red light, so.
You got a red light. You know what that means, too, don't you? You haven't mentioned your other 2 issues.
Right.
They understand them, though, I think. You have saved some rebuttal time.
Right.
You want to use any of your rebuttal time on either of those other issues?
I
You
will,
got the anonymous jury,
right. Yes, I'll go
and
ahead.
you got the error in the closing argument
Right.
that the government concedes, basically,
Mm-hmm.
that says it was fixed.
Right. So as
And
far as,
both of those are reviewed for abuse of discretion as well.
I think the anonymous jury, that we contend that's a de novo review, because that's,
Which one?
both. The anonymous jury,
Both?
that's,
Okay, that the judge's handling of the jury is reviewed de novo.
Right.
Okay, that's what you're saying.
That's what I'm saying. They may
Okay.
disagree with me, but, so in this case, you know, here we're talking about a case involving threats, and then the jury is told that they're going to be anonymous. And we know under the United States versus Dinkins case that there has to be a strong reason to conclude that the jury needs protection from interference or harm. And even if those exceptional circumstances are present, it still may affect the defendant's constitutional right to a presumption of innocence. The jury's getting the message that the defendant is dangerous. I think the very fact that these are threats does create the concern that the jury is going to conclude that they need to be protected as well. And there were suggested ways that could be handled by redacting the personal information. And
Judge just took off the juror's name. You got a client who, you know, he has some serious problems. He's threatening very serious threats.
Right.
Death and all kinds of stuff. And that's in the first 3 letters. That's there. And
Right.
But it's not totally anonymous. I mean, he let the biographical data come out and all of the other stuff. He just didn't allow the names.
As far as the jury, yeah, I had the biographical information so that I could do my job. The question was whether the jurors were gonna be identified by numbers, because that sends a message to them that there's danger. And I think that creates a suggestion to the jury that he's a dangerous person, even before the trial starts.
You had to assume that jurors didn't think that wasn't the way it was always done.
Well, that was the court's position, is that she wouldn't tell the jurors that it
Yeah.
was done
You come
differently.
in, you don't know what the court's doing. Some courts
That's right.
might do that, might say, okay, we're gonna call everybody 1, 2, 3, 4 on up.
That's right.
Counsel,
Yes, sir.
I'm looking, you said we, in your view, we reviewed this de novo,
For,
and,
no.
excuse me?
I'm sorry, for which one, the jury question?
I thought, the anonymous jury question.
Yes, sir.
Is there, I'm looking quickly at your brief, and I don't see anything that says that. I'm not, I'm not talking waiver or anything, but,
Right.
I mean, is there a case that you would point me to that?
No, I didn't find a case specifically on the standard of review for that. But
Why
this-
doesn't Dinkins, which you
right,
were talking about, it looks to me like Dinkins suggested,
Oh.
or says it's abuse of
it
discretion.
is, you're right, I'm looking and I correct myself. I'm looking
Okay.
at my own brief. It is a deferential abuse of discretion standard, so I
Okay.
apologize.
No, we're,
Yeah,
we're good.
I just had to put my glasses on. So, I've got 20 seconds left.
No, you don't have the 20 seconds left, you're over time
I'm
here.
over time, but
And we
I
might
mean, I
give
was
you,
into
I
my
might give you a
rebuttal.
couple minutes of rebuttal time later, but you're on
on borrowed time now.
our time, I guess.
Okay, well then I'll stop. and,
But we got that abuse, we got that
Um,
standard review
Right.
correct, and
No,
that's
Thank you for
important.
correcting me.
Yep.
Okay,
Thank you very much.
thanks.
We appreciate your work. Mr. Pant, then do you prefer a different name or something? What is, Mr. Prosecutor? How about that?
I go by Avi Pant, Your Honor.
All
So,
right.
May it
Mis-
please the court, good morning, everyone. Avi Pant for the United States. I want to pick up just where my friend left off. You know, the government's view on this fourth letter issue, that really the prejudice here attaches because there are threats to additional people imbued in this fourth letter. But that is what creates the context from our intrinsic argument. That's what creates the context for why. Because again, the government has the burden to prove his mens rea.
So you wanted to let us in for the very reason he complains about adding additional people and showing there were additional people, and not for a B reason, which seems to be pretty straightforward, indicating that at least maybe 404B2 would be satisfied here.
Not necessarily that there were threats to these other people.
Why you want to add that? If it comes in under 404B, why do you need it to make a second argument? I don't understand. It seems to me, it jumps off the page that the 404B argument, from the government standpoint, is the best argument.
Understand, Your Honor.
But you're entitled to take a different position, of course.
No, I mean, I think the 404B argument is, I mean, on reflection, is probably the better argument. But I just wanted to.
Sort of helps you when Judge King pointed that to you, didn't it?
It did, Your Honor.
But it may well be that either argument is good, or both are good, and I mean, that's another thing. But our friend on the other side says both are flawed, fatally flawed. That's
Yes,
the
Your Honor.
point. The question for us is whether both arguments are fatally flawed.
Yes, Your Honor, and I don't think they are. Just, my point was that what makes that relevant, Your Honor, is that it is the identification of those individuals that ties the threats to the Norfolk prosecution. The government's theory of the case is that he's threatening these people because they are involved in prosecuting him, in holding him accountable in the Norfolk case. And his mens rea.
And that certainly is admissible or relevant to a sentencing proceeding. Question is whether it's relevant to the trial on these other issues.
And Your Honor, I think it is because.
And the question is, and whether the government overtried the case by adding that issue here when they didn't have to.
I don't think so. And so I'll point, Your Honor, to United States v. White, which was a case.
I mean, it looked like you had, you could be saying you had an open and shut case anyway. And then you threw this issue in.
So, yeah, what's the, I mean, yeah, is there something you can contend that fourth letter gave you that you didn't have from the three letters?
Yes, Your Honor, and I think.
What is it?
I think the plus factor is the identification of, it resolves the question of why Mr. Beeman is threatening Special Agent Nicole Harris. You cannot garner that information just on the face of the count two letter to really understand the why. And again, we have to prove.
And identity is in 404B, isn't it? That one of the terms in there?
And I think that construct would help us on the 404B piece as well to prove motive as well as the subjective intent to threaten. I think under either construct, the government bears the burden to prove his mens rea.
So your position is that, I mean, I guess I hear you, it goes to that. I mean, it would have been a pretty tough row to hoe to say, hey, I got 3 threatening letters to people involved in the prosecution, but it really had nothing to do with that. But I guess your point is you got a standard of proof that's beyond a reasonable doubt. You got evidence that shows it, and you're entitled to put it in.
Yes, Your Honor, and this court said in United States v. White, you know, it says, and we appreciate that in many threats cases, the question of intent will be far from clear, even where it is undisputed that the defendant transmitted the communication and the message itself contains harsh and inflammatory language. We can only prove mens rea circumstantially. We can't unfold the thoughts of the defendant in front of the jury, and so we have to ask the jury to draw these inferences from circumstantial evidence that can help elucidate that he intended to threaten. The government has that burden, and I think that is important contextual information to be able to draw that out. And just to address Judge Wynn's point, the parties always treated this as an up or down proposition. I think, you know, had we been in a different posture where we said, hey, we don't need to talk about the threats as to all these other people, but just the mere identification of those people, you know, that might have been something we considered, but that was never objected to in that way, and the court never had a chance to consider that.
So for your case in chief, are you saying that the 3 letters would have not been sufficient evidence upon these charges?
No, Your Honor. I mean, I think the three letters would not fully explain his subjective intent, and maybe in hindsight, you know, they would. I think our evidence at trial came in.
Did the defendant put on evidence?
The defendant did not put in evidence.
So there's no opportunity for you to rebut anything that they put in issue there?
That's correct, Your Honor. That is correct.
And if you hadn't put that in, and he had taken a stand, you could have cross-examined him on it.
Absolutely, Your
That
Honor.
4th letter. And you could,
We absolutely
but you
could.
didn't, but you had to make a decision as to whether to wait and see if he got on the witness stand. That's right, and so you went ahead with it.
Yes, Your Honor. If I may just address Brizuela briefly as well, I think one of the key distinctions that you pointed out, Judge Quattlebaum, was, yeah, I mean, here, the letter is addressed to the same person. This isn't like this opioid case that we're talking about. For unrelated patient testimony, that patient misconduct has not been charged. That was the case of Brizuela. Here you're talking about a letter to the same person, close in time to when that original letter was sent, and reiterating some of the same threats, but also providing all this other information that makes clear the source of his animus is due to her involvement.
In other words, there's just wasn't any connection in the Brizuela case with the evidence that was sought to be admitted with the actual charges, whereas here you're saying there is.
Yes, Your Honor, and that would be a point of distinction between the two. And I'll say, I think the court recognized it is a fact-intensive decision, and, you know, I would submit for the court that Judge Locke, you know, really had a pulse on this particular evidence, and
it's reviewed for abuse of discretion.
and it's reviewed for an abuse of discretion.
That's always the government's best argument.
Yes, Your Honor, and
Or not always, but lots of times it is.
And I appreciate sometimes being led to the water. You know, even when I'm led to the water, I don't always know to drink. So I appreciate that, Your Honor. Let me move on, if there are no more questions on this, to the anonymous jury procedures. I just want to clarify one thing, and that is, the parties were in agreement as to all the jury procedures. The only thing that was in dispute was whether the jury would be instructed that, hey, jurors are referred to by numbers. It was the same non-prejudicial explanation that this court adopted and ratified in United States v. Hager. And that was the only issue. I know anonymous jury procedures can relate to a wide range of practices, but actually here, what it was fairly narrow. And again, it was a fact-specific inquiry, I think.
There's
Judge-
lots of procedures in jury selection that involve referring to jurors by numbers and things. I mean, that's maybe different context than this, but it's nothing abnormal, is it, to consider jurors by numbers in certain parts of trial procedures?
I think you're absolutely right, and jurors are coming into a stately courtroom. There's all sorts of procedure that they are being exposed to. There's no reason to think that they would come and look at the fact that they're referred to by number. Maybe that's just what happens in a courtroom. And I mean, I think Judge Locke balanced the equities completely in line with United States v. Hager, and really the defendant was not prejudiced.
Did the district court say the reason was to protect privacy or something like that?
Yes, Your Honor, and that's part of the instruction to prevent nosy onlookers from taking
But
undue.
was that right?
Is that right? And
Was that the actual reason, or was the reason safety for the jurors? I mean, and does it matter if you, it seems odd to me to say a reason that might not have been the reason, or maybe that is see what I'm getting at?
I understand. So is it okay to mislead or misdirect the jury, but not mislead in any pejorative way, but I think you have to balance that against the overarching
It really was for
interest.
their safety, wasn't it?
Absolutely. I think that's right, but it's about protecting the rights of the defendant. I mean, the alternative would be, I'm not sure how.
It seems to me the alternative is you don't say anything, you just do it, and you don't give an explanation that is, but that's, anyway, I just
And-
found that part interesting, that there was an explanation given that might not have been, the actual reason.
Understand, Your Honor.
But there's no objection on that basis, was
There was no objection on
Yeah,
that basis, and that's not really before the court. But the basis was really past attempts of Mr. Beeman to interfere with the judicial process. The fact that this entire Richmond prosecution in front of Judge Locke stemmed from his attempts to interfere with the judicial
Was
process.
the trial in Richmond?
Yes, Your Honor, the trial was before Judge Locke in
Yeah, I
Richmond.
know it was before Judge Locke. I thought maybe, I sort of assumed it was in Norfolk. But it was a Norfolk indictment.
Let me just clarify. So there was a predicate case in Norfolk, and that case was before Judge Young. That was also a threats case. And in the midst of that threats case, that's when Special Agent Matthew Hacken, AUSA Matthew Hacken, Special Agent Nicole Harris were prosecuting Mr. Beeman. That's when they started receiving letters. So Judge Locke found that itself is an interference in the judicial process, and that factored into the decision. I think she was correct in making that decision. It falls under.
Yeah, that's not challenged either. I assumed that the trial was in Norfolk for some reason. But it was up here in the new courthouse.
Yes, Your Honor.
That is a fancy.
Yes, Your Honor. Let me just touch.
And Judge Locke's an experienced judge. We know that. She's been around and tried a lot of cases before she was a judge.
Yes, Your Honor. Yes, Your Honor.
She knows her way around the courtroom.
Absolutely. Let me just touch briefly on the closing argument issue. So in closing argument, the government conceded that it articulated an incorrect standard for a true threat, implying that the true threat was a subjective standard to the listener rather than an objective reasonable person standard. Defense counsel, my friend to his credit, promptly objected The court promptly gave a curative instruction and told the jury to disregard the incorrect standard. Jury is presumed to follow instructions here. The government then corrected its prior misstatement going forward in articulating a correct standard for the rest of the closing. There's no dispute the jury instructions were proper in this case, and in fact, my friend referred to those jury instructions at length in his closing that followed. So the improper statement was slight and isolated, 7 lines in a 20-page transcript here,
And
corrected.
you agree there was a bad argument,
Without a doubt.
Okay.
It was an incorrect articulation.
and it was, and the
the
court,
standard.
and the court fixed it almost immediately.
The court fixed it immediately, and there's really no prejudice, I would submit, to the defendant from that episode. Unless there are any other questions, Your Honor, as I will take a seat. Thank you.
Thank you, we appreciate you. Mr. Dinkin?
Just briefly in response, going in reverse, as far as the anonymous jurors, the test for whether to do that, that's set out in Mathis, Mr. Beeman doesn't check, well, he checks 1 or 2 of the boxes, but the balance favors him. First, he's not involved in organized crime, so there aren't people on the outside or associated with him that would take out some type of retaliation against the jurors. So there's not the capacity to do it. His past attempts to interfere with the judicial process were limited to making threats to the prosecutor, not to anyone, well, until the 4th letter associated with the prosecution.
That's
But-
kind of important, isn't it?
Pardon me?
Kind of important. that
Yeah, well, it's
fourth letter.
important. It's a factor, but.
He's being
but-
tried by people, then he turns around and make threats against the people
Right,
tried.
yeah,
What
but
do you
there's
think
not-
he's gonna do with the jury?
And he's looking at a 10-year sentence. He's incarcerated, he doesn't have anyone on the outside to do anything about it, and there's not any publicity on this case.
Did you represent him in that first case before Judge Young, or just in the case before Judge Locke?
I was appointed as standby counsel. He decided he wanted to represent himself. He had.
Oh, he tried that case himself.
Well, he pled and then wanted to withdraw his plea. The basis for that motion to withdraw was that his trial counsel there, he said, threatened him, ironically. And so he decided to represent himself, and I was standby counsel on that case. But there wasn't, on none of these cases was there any publicity, and so that's also another factor in the Mathis prongs. I think if you balance all that out, you're balancing one prong, which is the fact that he had made threats during the judicial process previously to people involved versus all the others, and I think the balance can easily fall in Mr. Beeman's favor. As far as the closing argument, to touch on that just briefly, the prosecutor, not Mr. Panth, but his co-counsel, argued to the jury, how would you feel, essentially, to paraphrase, how would you feel if you received one of these threatening letters? And that's, of course, not the standard. They concede that. The standard is an objective question of whether it's a true threat or not. But it's hard to unring that bell.
But it may be, but that essentially, I mean, lots of times there's objections about things that are said in closing that shouldn't be. You may refer to something that you want in evidence, or you may do this or that. And we all, I mean, if the trial court's correction and instructions don't cure it, then we're almost saying there's no error that can't be fixed. I mean, I get your argument that this is improper, but I don't think I've seen anything about this particular error that is, at least from a court opinion standpoint, so different than other potential errors that it's beyond being fixable, which it sounds to be, must be your argument.
Yeah, I think I I inadvertently provided you a good example today. I made a mistake. I misstated the standard for the standard of review for the jury question. You corrected me. There is no question that you all will understand the difference. The jury, however, has been told that how would you personally feel? And now they're thinking, and there could be all the correction in the world. Now they're thinking, my God, how would I feel if I received one of these letters?
I guess
Maybe
my
they-
question, I understand the argument there, but is there any authority from us, another circuit, state court, anywhere that says this type of error is so inflammatory, so beyond repair that it automatically results in a mistrial, and can't be remedied by curative instruction?
No, I don't have anything one way or the other on that. And so I can't point to a specific case that I could hang my hat on, at least not that I found. Now, just
You're
going,
running through that red light again.
I am into the red light, so I will stop. Thank you very much.
We understand your position,
Thank you, Judge.
and we appreciate your work.
Well, thank you.
We appreciate the prosecution's work. And we'll come down and greet counsel and then go to the next case. In our second case today, we have number 24, 1383, Hebb versus the City of Asheville. Mr. Edgerton? Yes, sir. You're here for the city? Yes, sir. Good to have you, sir.
Good morning, honorable judges, and may it please the court. My name is Eric Edgerton. I'm a senior assistant city attorney for the city of Asheville, North Carolina, the appellant in this matter. And in what's probably a fraught proposition for any attorney, I'd like to start with some math. I specifically want to talk about two numbers that I think are relevant to our consideration today. The first of which being 40. 40 is the number of times that the parties in this matter cited to the case of Medlin v. Palmer in their briefing to the district court. Now, Medlin v. Palmer is a 1989 decision of the Fifth Circuit, and if your initial reaction is to wonder why such a majority of the parties' briefing would focus on that case, the explanation is simply that the facts are virtually identical to those at issue in this case. It involved a municipal regulation on the use of amplified sound within 150 feet of a medical clinic during those hours in which it is open and operational. That's precisely what the ordinance at issue in this case, Section 10-852 of the City Code, does. The claims presented in Medlin v. Palmer were also the same as the instant case. It was a First Amendment challenge to that ordinance's validity, as well as a due process clause challenge to that ordinance's validity. That identicality of issues explains why the parties would have spent more time briefing the case of Medlin v. Palmer than any other to the district court. The second number I want to mention is 0. 0 is the number of times the district court cited to or otherwise acknowledged the existence of the decision of the Fifth Circuit in Medlin v. Palmer. But that also should not be surprising given the procedural posture we're in. The
Also
city,
not surprising because it has no precedential value here.
yes, and
You
that,
can only look for it for guidance.
And thank you, Judge.
1989, and he just might have decided, I don't need to cite it.
and thank you, Judge, Wynn. That delivers me directly to where I was going to wrap up my initial opening, which is to say that the bigger problem is not that failure to acknowledge the existence of this Fifth Circuit precedent, even if the facts are identical. The bigger problem is that every legal principle acknowledged by the Fifth Circuit on each of the three prongs of the First Amendment test and on the issue of the Due Process Clause are 100% the same as the principles that this court has acknowledged in its own precedents. And so for that reason, I don't intend, Judge Wynn, to use this 1989 case as some sort of shorthand or cudgel to say, well, the Fifth Circuit did this, you have to do the same thing. Rather, I'll use it as a roadmap to go through each of those prongs and direct this court back to exactly where you've endorsed the self-same legal principles that led at least one other federal circuit to conclude that a municipal regulation on the use of amplified sound within 150 feet of a medical clinic during the hours in which it is open and operational to be obviously constitutional. And with that, I'll move into the first prong of the First Amendment standard. This is going to take the least amount of time. This is the substantial government interest question. I believe this is largely resolved. The district court at page 371 through 373 of the Joint Appendix essentially recognized that this standard should be satisfied or should be found to be satisfied. And that's,
The district court did, and I'm just trying to figure out how we look at that. There's certainly precedent that talks about the concept of, the interest the state has in medical patients having an environment that allows them to recover. So in that sense, maybe that concept is not in controversy. But there is controversy about whether that particular interest was really what was being, was the reason behind the ordinance.
Certainly,
I mean,
Your
the
Honor.
district court cited facts. You might disagree with those facts, but they were that, that these things originated about, there were in the record, there were complaints about music, that there weren't any complaints from any other medical providers. There weren't any complaints about schools. There had been, some communication about the clinic with the city, but to the district court, those facts were important and said maybe this interest is there, but the district court's review of it was that the record showed that interest may not have been the actual one advanced.
yes, Your Honor, and I think that we can resolve this issue of how do you reconcile the substantial governmental interest prong with the district court's analysis in the regards that you're talking about. That's the over-inclusion or under-inclusion analysis that the district court went through.
Well, that's a separate issue. I mean, the first issue, I think, is do you get to claim in general, an acceptable interest if the record shows that wasn't calls into question whether that was actually the city's interest?
Yes, so my answer would be directly that the standard that this court has set forth is that if you have established in the past that this is a compelling government interest or a substantial government interest rather, that you can rest on that would essentially settle the issue.
So you can say an interest that is generally acceptable, and if the record would show that's not what you were really interested in, you get to just say, well, yeah, y'all have already said this is okay, so I'm good?
No, Your Honor, because those facts can then still be presented in the narrow tailoring argument.
Okay, so that's just in a different part of the analysis?
Exactly, Your
I
Honor.
got you. I'm
Yes,
sorry,
sir.
I jumped ahead.
No, and that's our next stop. So unless there are any further questions on the substantial government interest, I'll move straight into the narrow tailoring. And so when I say that this Fifth Circuit case set out the same exact standards that you all have endorsed, I mean that quite literally. And so this court in Ross v. Early has set out the standard in stating that municipalities need not, and I'm quoting, quote, regulate using the least restrictive or least intrusive means available to achieve its goals. Put differently, so long as the means chosen are not substantially broader than necessary to achieve the government's interest, the regulation will not be invalid simply because the court concludes Government's interests would be adequately served by some less speech-restrictive alternative, end quote. That's the standard. It's not a standard of infallibility. And so when we have a record before us, we know what the city did to tailor this ordinance. We know that it specifically restricted the application by distance. 150 feet is all where it exists. It restricted it by hours of operation. And so it's not in effect when clinics are closed. That has been found by multiple other federal circuits and district courts within this circuit to be a sufficient level of narrow tailoring to survive First Amendment scrutiny.
Do the facts about the citations to the plaintiff here before the ordinance was in place, is that relevant at all? I mean, he was cited, it seems like, by the city's own acknowledgement improperly the first time. And then Mr. Woody, who is normally not the person who issues citations, comes and cites him 2 other times about an ordinance that doesn't even exist yet. Does that bear on anything here?
Just to clarify on the factual basis, I don't believe Mr. Woody's engagements with the plaintiff constituted citations. I think they were actual just direct communications by email. No citation was issued, but he did say, I took these readings and I wanted to let you know what they showed.
Well, maybe I'm in weeds that don't matter, so sometimes that happens with me, so I'm sorry if that's I thought he was cited one time, not by Mr. Woody, but by someone else. He brought to Mr. Woody's attention the fact that he was cited, and Mr. Woody said, what you're doing is not improper under the current ordinance, and that kind of got it dismissed, basically. And then later, I thought, maybe I'm wrong here, that Mr. Woody himself carried out and handed some sort of citation around the time, but before the new ordinance went into effect. Am I wrong about that?
On the latter instance, that doesn't strike me as probable, and I don't have a clear recollection of that being in the record. That would not be within Mr. Woody's normal job function whatsoever, and so that would be.
What was Mr. Woody's title?
He's currently the assistant city manager. He was the director of development services
I
at
know,
the
but he
time.
was sued here, and I didn't know what they.
Yes.
But he's assistant city manager.
He's the assistant city manager now. At the time of these proceedings, he was a development services director. He was probably.
Development Services Director,
And
that's the relevant title.
Right, and so he was probably the primary city employee involved in the drafting of this ordinance and the development of it. So that would be his involvement. But to answer your Honor's question, Judge Quattlebaum's question about the initial citation, I think it is instructive. I think it is relevant because that gets to what initial problem the city was looking at as it embarked on this initiative to revise and reform its noise ordinance. It had this just purely subjective standard in place that was extraordinarily difficult to enforce. It was not resulting in corrections to the types of behavior that you want to discourage with a noise ordinance. The record shows that there were, and I'm at page 56, that there were numerous complaints continuing to be received from this immediate area of the city of Asheville's medical district. And so that.
You're talking about like, there are all these complaints from all these medical providers. Maybe what's the evidence of complaints from medical providers other than AHC?
Yes, I appreciate that question, and I don't believe there are any other complaints other than from in this immediate area.
So that's fine, and they're a citizen and they're entitled
Yes.
to make complaints, but the notion that the medical community in general is complaining about this just isn't supported by the record. It's a particular clinic's complaints.
Yes, I think that's fair, and then I would refer the court to what the Supreme Court has said in McCullen v. Coakley on this issue, because it's dealt specifically with it. It said the government's, quote, adopt laws to address the problems that confront them. The First Amendment does not require states to regulate for problems that don't exist. If there happens to be a specific group of people who violate one law or one ordinance more than others, that does not give rise to a First Amendment claim. It just shows that they are more prolific in violating the law at issue. If the law remains content neutral on its face, it is subject to the same First Amendment analyses as any other ordinance would be. This court.
Maybe not anomaly, but it seems if we hold this ordinance as content neutral here, and yet an individual chooses to express a viewpoint type message, and it affects a particular group or particular clinic, the question then becomes, does that change it from, at least the purpose of the ordinance that we've held to be content neutral, does that mean it then is a viewpoint?
No, it has to be balanced against that quoted principle that I just referenced from the Supreme Court, which is that you adopt laws to address problems. So yes, if you have evidence that it was targeted at some specific individual, if it amounted to something like a bill of attainder, that could be a problem. But you don't jump there. You don't assume that malicious intent. That's also, to do so would be inconsistent with the deference that is typically given to municipalities and their legislative decision makings.
Counsel,
On the specific-
go ahead and finish Mr. Twynn's question, I'm sorry.
Yes, Your Honor. On the specific question of how that plays out in this context, I would analogize to 18 USC 248, which prohibits certain forms of speech or conduct in the immediate area of the entrances to reproductive health clinics. And in discussing that law, I believe it was that law, is the Second Circuit stated, quote, "It is irrelevant whether in practice most of those prosecuted under a law are anti-abortion protesters. First Amendment law does not recognize disparate impact claims, and a group cannot obtain constitutional immunity from prosecution by violating a statute more frequently than any other group." And so when the behavior at issue is anomalous and limited to a small subset, yes, they can claim that they were being targeted, but on the facts available before this court, it is demonstrated that most of the complaints had no references whatsoever to the content of the messages, but were focused on the fact of amplification. That's at page 348 of the joint appendix. And I'm sorry, Judge Quattlebaum, I think
No, you go ahead, you're good.
Okay.
I don't want to belabor it, but I've looked at the complaint, and the complaint does allege that Mr. Woody cited the plaintiff twice in July of '21 before the ordinance went into effect. And so, that's what the allegations are. And we're talking about, we got to accept those as true at this stage of the case.
Thank you, Your Honor. And if that bears on the First Amendment analysis, I'll be happy to revisit it, but.
I hear you. Maybe it does, maybe it doesn't.
And so that's the narrow tailoring prong.
Can I ask a question? You're running out of time, and I'm probably partly to blame for that, but can you point us to any, a JA site where the city considered a less intrusive ordinance to the speech that the plaintiff sought here, or then was contained in the ordinance?
Yes, Your Honor. And so there's the background information on what the reality was when the city was operating under just that subjective standard, that noise disturbance standard that I mentioned. And so with the record of receiving all that body of complaints under that former standard is at page JA 56. The district court actually concluded that was what was going on.
So those are, just to help me out, those are complaints from the clinic?
Those are complaints from the medical district, from that area. And if Your Honor is pointing out that they're almost exclusively, if not exclusively, from this one clinic, I'd accept that as so. But that's the body of complaints that demonstrates that's purely subjective standard was not functioning as it should. With respect to the
Does the fact that no other medical providers in this medical district complain suggest the opposite?
Well, I will tell you that some of the complaints, and I believe they're included in the joint appendix, were from other medical providers about the same individual, but those are medical providers that adjoin or are nearby the clinic that Your Honor is
So they're
referring
not from the clinic itself?
No, I can conclusively say that 100% of the complaints did not come from the clinic. Their surrounding community as well have this
What
problem.
else is out there in the medical district?
It is as you would think of any medical district. It's a concentration. There's a central hospital, and then in the radii going out from that, there's
Doctor's
any number.
offices
Dentists, anything.
and a hospital. The main hospital of Asheville?
Yes, Your Honor. Yeah, Mission Hospital, yes. And then you,
Aside from the complaints, what is there that there was actual consideration of less intrusive means and why those didn't work?
yes, Your Honor, and I'll address this when I come back up. But
Sure.
just to preview, I'll tell you that it's that we considered the use of decibel limitations, and then the consideration for why that would not be sufficient appears at JA 114, 115.
Is that the Woody affidavit?
Yes, Your Honor.
Okay.
And then just to make sure that I cover all these while I'm still up here on my initial statement, the ample alternative means of communication, I believe, is going to be equally clear-cut. This court has said also in Rossby earlier that the alternative channels need not be the speaker's first or best choice or provide the same audience for the impact of speech. It simply has to, the relevant inquiry is simply whether the challenge ordinance, challenge regulation provides avenues for the more general dissemination of a message. In our briefing, we provide you with the decisions of 2 other federal circuit courts that say restrictions on amplification obviously still allow alternative means of communication. On the due process issue, we've explained in our briefing why it should have been subject to a deferential standard. There's a default assumption in favor of constitutionality that the district court seems to have ignored when it was trying to interpret whether the term amplified sound was something that normal adult human beings could understand. I think we can all reflect on that as such adults ourselves. The additional canons of construction that the district court disregarded include those that require that when a general term is used, you assume it actually meant the general term. So the district court erred here by assuming that when the city said you can't use amplified sound, it must have really meant you can't use either mechanically or non-mechanically amplified sound, and determined that there was an ambiguity on that basis. When the city says amplified sound, you should assume that it meant amplified sound. And to go back to Medlin v. Palmer, that court, the Fifth Circuit, analyzed the exact same issue and found that there was no basis to find a due process violation. So I'll revisit in greater detail the decibel issue when I come back up, Judge Quattlebaum, but for now I'll sit.
Thank you, Mr. Edgar. Mr. Kellum?
Good morning, and may it please the court. My name is Nate Kellum. I represent the plaintiff, appellee, Zachary Hebb. At the core, this case is really about the right to be heard. Mr. Hebb has a fundamental right to free speech, and that encompasses a right to be heard, and Asheville's ordinance infringes on this fundamental right. The ordinance is not narrowly tailored to a significant government interest. It goes far beyond any legitimate interest in trying to curb excessive noise because it eliminates all use of amplifying devices or plastic cones within any reasonable distance of this particular clinic.
If your client was 150 feet away and had his iPhone and it was on speakerphone, turned up high, would that be amplified sound?
Even without being, it would, even without being particularly loud or high, because it's not dependent on the loudness. It's just dependent on the device, which could be an iPhone. It certainly could. And so, and because it does depend on the device and not really the sound level, that's where this ordinance goes constitutionally awry. The overreach is particularly troubling for Mr. Hebb because he doesn't wish to speak loudly. He wants to speak in a conversational tone. That's really the only way it can be effective when he's trying to reach individuals as they're trying to.
Well, I've never heard anyone speak conversationally with a cone. I hear conversation's great, but does saying, maybe he's going, that just, those two things, saying you want to be heard and use a cone, I get a lot of the arguments.
That's fair enough.
That seems odd to me. If someone wanted to talk to me and was doing it with a cone, I would think you aren't trying to have a conversation with me.
Primarily, that would be with the amplifying device, like I'm using a microphone here, where I'm trying to speak conversationally. I don't think it'd be very effective with the panel for me to yell from the microphone.
What do you mean by a cone? Something, how big is it?
Like a cheer cone.
Well, how, is it 2 feet, 3 feet, 1 foot?
He's used different types of
Uses-
cones, and that's not in the record, Judge King, but basically it's a plastic
Well,
cone.
what do you mean? When you're about to, you used the term right there.
Sure, it's like a 1 foot, 1.5 foot cone where it's plastic, where it
All right.
basically has a
And
smaller
He talks through
circle.
it. and
Exactly.
That and that, you say that doesn't amplify the sound.
It directs it,
It-
is what it
It
does.
directs it.
Yes, and so
Doesn't amplify it, it directs it.
it directs it, and it makes it,
And where does he direct it toward?
it directs it toward the people he wants to hear his message.
And that were the people going into this clinic.
Yes, Judge, that's right.
He never alleged in his complaint that he wanted to use a cone. He did it in the preliminary injunction motion, but it's not in his complaint.
That's not his primary thing, but he I think, put it in his affidavit, and I thought it was in his complaint, but he definitely wants to use a cone if an amplifier is not available. He doesn't make any bones about it, Judge Wynn,
His basis
that-
is that his friend wanted to use a cone.
his friend, no, that's how he learned about it, Judge Wynn,
Yeah,
was
and it's the
when his friend.
Not him, so isn't that a standing issue?
I don't believe so, because he wants to go out there with a plastic
Well,
cone.
at
That's
least when you
what the
want to
evidence
challenge
is.
void for vagueness,
That's
you
right.
gotta be specific on it. You didn't put it in your complaint.
I believe it's specific enough, Judge, because he says that he wants to use a plastic cone as far as that was put in the preliminary injunction, is put also in the summary judgment in his affidavit that he
But it
wants to
didn't
use
put
a
it in
plastic
the
cone.
allegations that brings the matter to bear. It's not in the complaint here.
Judge
And
Wynn,
it's not
the
something
complaint,
that you've indicated, Judge Qualbon, it's certainly not something that you expect he's gonna get up and use his regular voice. He's not gonna do that. I guess a comb sort of works because you raise your voice and it has a way of projecting it even louder, but maybe a regular voice somewhat louder, but it's not gonna be enough to probably satisfy what he wants to do. I mean, he can
It
yell,
definitely- it definitely
he
interferes.
can yell, he can have signs, he can do all kinds of stuff. But what he wants to do is he wants to have an ability to talk, something that will project his voice loud so he can project it further, or so it can be heard in a different way.
I would say both, but primarily that it could be heard in different ways, so it could be heard in a conversational way, as I'm speaking to you, Judge Wynn. That's what's in the record, that's what's effective for him to be able to, because he wants to talk to him, talk about, hey, we have other options, we have other things you could consider. And so he really wants to start a conversation.
Do you agree that ordinance is content neutral? I mean, it doesn't mention anything specific here in terms of viewpoints.
It's focused on particular locations, so I think under current Supreme Court holdings, it is content neutral. That
So
really wasn't
immediate
the
scrutiny
argument.
is what we're applying here.
I'm sorry, what's that, Judge? Wynn?
Immediate scrutiny is what
Yeah, it's intermediate scrutiny. Whether, is it narrowly tailored, and as a question was raised about, does it advance a significant government interest? Which it falls short in that as well, because while I think excessive noise, curbing excessive noise can be recognized as a legitimate interest.
So he's allowed to communicate, he's allowed to have speech, but it's the manner in which he wants to communicate. Is Asheville required to honor the manner in which he wants to communicate?
That's what the court held in McCollum versus Copeland, where it talked about the significant burden imposed on conversational speech.
What do you do about the law, your colleague cited that, you don't necessarily get your preferred manner of communication? There are cases that state that. What's your response to that principle?
Certainly, and that goes to the third prong, which does it leave open ample alternative channels of communication? And so that's really separate from the narrow tailoring, but as far as leaving open ample alternative channels of communication, that's an issue as well, because yes, while there certainly are cases that state that it can't be necessarily the best or preferred, it is recognized it has to be adequate. It has to be something that fulfills what your mission is, why are you out there? And I think McCollum versus Coakley is really spot on with this, because it speaks to the ability to be able to have these type of conversations. That's really not good enough to be able to yell at somebody, because that's not how they want to be able to fulfill their mission. Their mission is to be able to create a relationship, to be able to start a conversation, and you simply can't do that by
In
yelling.
the, our case, I think it's pronounced Pomerleau.
Yes, yes, U.S.
A
Labor
helpful
Party versus
case
Farmer,
to
yes.
you. I mean, it talks about the benefit of amplified communication. And that, you know, and looks and says that if amplification is not really much different than a normal person communicating louder than normal, that, you know, that's a type of speech that is, in that case, protected, and an ordinance that said, that prohibited that was not. So I guess I'm a little trying to figure out exactly where you're going. I mean, I hear the thing about conversational, but it seems like the reason he's using a cone is he wants to be heard. And he knows that if he's just talking, presumably he won't be heard. So, yeah.
Well, that's certainly right in this case, because he does need to be heard. And he would prefer to be able to speak in a conversational tone as I'm speaking. But at the bottom line, he needs to be heard to some degree. And what you have here is that you have a buffer zone that goes 150
So
feet.
the buffer zone means that he has to amplify and use the cone.
Well, not the way the buffer zone,
Because he can't get by with the normal conversation, because he's too far away.
he's too
Because
far.
the buffer zone.
He's too far away because within just the 150
So
feet.
he has to amplify, because so the buffer zone requires him to amplify, to do what he wants.
Well, being private property and on a public sidewalk to a certain extent requires him to amplify as far as what he wants to do, because you have people that park in the parking lot, they're walking toward the building. So he wants to be able to use amplification. The
He
150
wants to
foot,
amplify for the patients walking from the parking lot to the clinic.
that's right, Jeff.
And how far are they walking? 50, 60 feet?
It's about 50, 60 feet. And so
50?
50, 60 feet, you're right.
50,
And so
60 feet.
It's not much time, really. And so he's trying to get a
He
conversation
wants to be
started.
heard,
He wants to be heard.
so he wants to be loud,
Or
so-
loud enough.
because there's a buffer zone.
Loud enough. Well, not because, I mean, he wanted to do that regardless of a buffer zone, because he's on the public sidewalk and he's trying to speak on people on private property in a parking lot. But with the buffer zone, he can't speak on the public sidewalk.
But I don't think the requiring that he be actually heard is part of the First Amendment. He is allowed to speak. And then you get the people who, if a person doesn't want to hear it, or if there's another means, in other words, the best way for your client would be, well, let's put some speakers actually inside the building where he gets to talk continuously, and that, that's excessive. But I'm thinking of an instance like if you had a clinic, let's say that did transplants of hearts, and there were people who were against this whole deal that you shouldn't be taking another human's heart. I mean, where do we draw that line that you can stand and yell, you can talk, okay, that's fine, that's your speech. But to the extent that you can amplify it to whatever degree, and then individuals in there they're being forced to listen. So the question is, where does it get that line where the speech is not just speech, it is also forcing it to be heard? Where if you have individuals, you do have people that don't want to hear it. And I know that doesn't factor too much in the First Amendment, but the First Amendment says you can speak. And so then when you reached in this intermediate scrutiny test here that you're dealing with, and there are other cases that dealt with, the Medlin case was one, it's 1989. There's a bunch of other cases. Judge Flanagan's got a case down in the Eastern District of North Carolina that sort of cut against it too. And the question then becomes, we want to be sensitive and say, we want you to speak, because First Amendment stuff is like privacy. I mean, speech is big stuff. But then what is the limitations of a city and protecting its citizens, or in this case, people who are undergoing surgery? It's not transplant surgery, but you could well see. I believe there's probably is a group of people out there do not like the fact that you take human hearts from a person and put it on another one. They think that probably violates something. And it probably wouldn't be very comfortable to someone who's receiving it nor their family to have someone outside that building constantly yelling, you can't take this person's heart, and that sort of thing. And the question is, where's the cutoff? And what's been allowed here is some sensitivity. You can speak. you can yell, you can put up signs, you probably can, maybe the cone, I don't know, maybe the cone could be violative of it, but your client doesn't know, because he's not done that. So, I mean, where do we go with this? I mean, there's some sensibility here and sensitivity, and it's not addressing the viewpoint.
This-
You know, you're entitled to to express your viewpoint. The question is, to what extent must your want and the manner in which you want to do it be addressed? And could it be, in terms of what, is it your subjective desire or what you want to achieve, or is it the objective aims of the First Amendment speech basis?
It's objective aims of the First Amendment, and that's why decibel levels are the way to go. Because you have a decibel level in a commercial area, which this clinic is located at 65 decibels. He was complying by that, and complying by that, you can't hear it in the center. There's no complaints of ever hearing it inside the center. And so that's why you use the decibel level. That's the way you're judging sound that way.
The
And
clinic
so a
put up
person,
soundproof walls,
so-
would
so-
that violate his First Amendment, because now he's not allowed to be heard?
not at all, it wouldn't. Because if a
Do
person.
they have
so
soundproof
he-
walls
he-
up? Do they have soundproof walls?
I don't know that they did, but quite possibly. But if
If
he's
they
yelling,
did, then you'd have no argument here today, you're saying.
no, I'm not saying that. What I'm saying is that he could be yelling at the top of his lungs, and he could possibly be heard inside the clinic, because he would be much louder.
And
than
that
he
would
is with
be
using an
permissible.
amplified
Can it be
device.
heard when the people are going in the clinic? In other words, he wants to communicate with a particular group of people. Can he communicate with them? He wants to communicate while they're in the clinic. Is that it?
No, he wants to communicate while they're walking.
He just wants to communicate while they're walking at 60 feet.
Yes, Your Honor.
But
the
they're
car?
walking from somewhere.
They're going from their cars to the building.
Why don't you point the parking lot?
He
Why don't
can't,
you argue-
it's a private parking lot. He can't park in there. All he can do is be on the public
So he
sidewalk.
can't get close enough to project his voice to the parking lot. And the parking lot is so close to the building, there's no chance for him to do it. It's like going in a tunnel there.
Oh, it's not quite like a tunnel, but you're talking about a distance where that's where an amplifying device.
And those he
is-
wants
is
to talk
needed.
to are young women,
Or families. It could
generally
be
their family, and their families,
their families.
and young women in sensitive situations.
Right,
Correct.
which is recognized as constitutional, is being able to do that. The question is
No,
really.
but I'm just asking you, they're usually young women in sensitive situations that he's wanting to talk to.
That's not in a record as far as what that is, but I think that's recognized that you have young women, you could have older women, you're having someone who's looking into getting an abortion. And then you have some other folks who are interested in it as well. And sometimes they're being compelled to do it. And so they're
sorry.
trying to address those individuals.
Sorry to cut you off there. First of all, I think just, as I understand, I looked at the complaint, and at paragraph 105, it said Smith gave the amplifier back to Hebb, and he proceeded to use it, sharing his views about visitors. I think that's the allegation you're talking about, where Mr. Hebb is using that cone. Is that right?
Yeah, sometimes he's not always using an amplifier. Sometimes he does use a plastic cone, and those are the type of
Is
instances.
amplifier something other than a cone when you're using it there? Or is that like a mechanical amplifier?
It could be either. In that particular situation, I think it was using a plastic cone, but I'm not certain about that.
Okay, all right.
But what I will say is that it uses different devices, and also with the, what's required for the city here is that they have to show that they have explored other ways.
That's what I was about to ask you.
Less intrusive speech ways.
You heard your colleague say, he gave me a cite to, I think, the affidavit of Mr. Woody and the complaints at JA 56. So he's going to say that is the evidence that they did that. What's your response to that?
Yeah, that's all they have, and that's what this court referred to in Billups versus City of Charleston as a post hoc justification. There's really no evidence at all that they considered other options before deciding to go with this flat ban. or that they just determined that it wouldn't work. The
So what should they have done in your view?
They had this study that went on for like 2 to 3 years of noise, and this issue really never came up. It just never came up. But had it come up, then they would say, okay, what are our current laws, are they working? And it would seem like that they were, because actually there were citations that were issued to Mr. Hebb.
Why isn't it enough to say that the people connected in some way with the clinic there complained? There was at the time a decimal level. Why isn't that effectively considering a decimal level? Which is a different alternative.
You have a citizen complaining about things are going on outside their facility, but there's no showing that they considered it and said, okay, just because you have a complaint, and really also I think that's just not sufficient, because you have to actually take a look at the legitimacy of the complaint. How can we best address it if it is legitimate? Are our decibel levels, are they working? Also, we have a multifactorial noise ordinance. Is that working? And so those are the type of things that they could and really should have looked at here.
Should they have looked at 100 feet versus 150 feet or things of that nature?
I think anything where you just completely shut down a device that was recognized in the Pomerleau case, was recognized in Say versus New York as an indispensable instrument for speech, I think it's going to be dubious from the start. So really, it would seem like instead of dealing indirectly with devices, why don't you deal with the sound level? Okay, what sound level is appropriate? Maybe you determine that outside of medical clinics, outside of public schools, we need to have a lower decibel level as opposed to a higher. Maybe that's the way to go about it. But at least then you're dealing with something that's more direct, what you purport to be the actual issue, and that is excessive noise. And that's something that's just simply not done here. Because what happened, this was a last second addition, which had nothing to do with their everything that led before the noise ordinance. And so I'm out of time, so if you have any other questions, I'll sit down. Thank you.
I'm fine, thank you.
Thanks very much, sir. Mr. Egerton?
Yes, Your Honor, and so I will, just follow on, I know I promised that I would come back to the decibel levels, but just because I think this is a quick one-off, I'll just point you to one further clarification I think is necessary based on the substance of my friend's argument regarding the ample alternative means of communication. Judge Wynn, you hit on the issue that this circuit does not recognize a inherent right to be heard by whomever you want to hear you, wherever those persons may be. That's a correct assessment of the law under Ross v. Early. The briefing for the appellee in this matter doesn't attempt to contradict that. What they do instead is that they cite to a Seventh Circuit case called Weinberg v. City of Chicago, in which the Seventh Circuit said, yes, you have a right to have these people hear you. And that's not typical of really any other federal circuit. I'll tell you, the Seventh Circuit also, immediately thereafter, there's a scathing dissent in the petition for rehearing en banc in Weinberg, because at least 4 members of the Seventh Circuit recognized at that time that was wrong. The Seventh Circuit referenced the decision in Weinberg in 2016 in a case called Left Field Media, LLC, and deliberately chose not to re-endorse that standard. And so they don't present you with any Fourth Circuit argument saying that they have a right to be heard by who they want to be heard by, because that's not the standard. What they do is instead pivot to what seems to be dubious law from the Seventh Circuit. But to return to Judge Quattlebaum's question about the decibel levels, there's been this sentiment suggested that this is an ad hoc or pretextual explanation, that the city didn't really consider the decibel levels, or that its reason for not using decibel levels in this particular area, which is a public right-of-way, is not sensible or is not a real concern. So 2 things on that. I've given you the joint appendix citation for where the affidavit of Mr. Woody explains what they were specifically looking at, the enforcement concerns that they had that led them.
You gave me page 56?
No, I'm on 114 and 115. That's
Okay.
the explanation of why a decibel standard would not be sufficient. Noise in rights-of-way tends to be transitory in nature. It's not like going to a set property where noise is emanating from and you can measure from the property line. The transitory nature of noise within a right-of-way is what, or other public space, is what makes that a distinction. And Your Honor, I see the questioning look. That's not just Mr. Woody's interpretation. That's not just the city's interpretation. This circuit has recognized, and in fact did so in the Pomerleau case, that that's an exactly correct concern to have about enforceability. And so I'll read from that case, where this court said, quote, Baltimore's ordinance as applied to the amplification of political speech on a public street does not meet these tests. The evidence discloses that in commercial areas, the Bureau of Noise Control cannot follow the ordinance's directive to measure decibels on the property line of use. Instead, its investigators measure volumes from points where they have observed pedestrians or expect them to be. The speaker is thus penalized unless he is able to correctly guess where the investigator will take a measurement. Because a violation depends on the subjective opinion of the investigator, the speaker has no protection against arbitrary and capricious enforcement of the ordinance. And so that's this court in 1977 explaining exactly why a decibel level in a right-of-way is an improper and problematic method of enforcement. The city worked through that concern up front and came up with an alternative means of regulation, which is now before this court in section 10-85 of the ordinance. The final thought that I will leave you all with is to just return to the fact that we do have a case on all fours from another federal circuit. We've been talking about this court's actual precedent as we work through each of the prongs, but I do want to regroup by just pointing out the Fifth Circuit looked at a municipal regulation on the use of amplified sound within 150 feet of a medical clinic during the hours in which it is open and operational. Exactly what this ordinance does. And determined that it was not even a close call. The language used by the Fifth Circuit is phrased in terms of obviousness, that there was clearly no constitutional violation. And so I'll just close with the words from a 2023 opinion of this court, which was, it was in a matter of the Brooks v. Kijikazi, where this court said, put simply, the Cody decision is practically on all fours. And there's no reason for us to reach a different conclusion and thus create a circuit split. Now, Judge King, those words are as correct now as they were when you wrote them back in 2023. You have a case on all fours. There is no reason to create a circuit split.
Was that a holding or just an observation?
Sorry, Your Honor.
What I was saying, was that a ruling or an observation?
My
I
observation
may have been
is-
musing or something, I think.
No, that was part of the analysis, that where there is a case on all fours, and it seems
But
fairly sensible.
Judge, I take very seriously anything Judge King says, because he's always right. But just, and I think we should, and I'm sure what that case says is we should carefully consider, what other circuits do. We learn from them. And we shouldn't lightly create a circuit split, but I think Judge Nguyen mentioned this earlier, and I think it's pretty clear that we're certainly not bound by the Fifth Circuit's 1989 case.
No.
And if we think this case is appropriate based under the standard review, whatever, I don't think you're suggesting we should say, well, we just gotta go with what they did in that case.
That's what I've told the court up front. I'm not gonna use this as a cudgel. I'm saying we've gone through every single principle. On top of that, I just happen to think Judge King was correct when you say that if there's a case on
Like
all
I said,
fours,
Judge King's always correct.
then on that point of unanimity, I'll sit.
You didn't mention the Pine case, which is 11th Circuit case, points in that direction too, but you don't have to, but I'm just
Your
saying
Honor,
you didn't.
I'm trying to be as charitable as possible. We have an ordinance that's 150 feet. Pine was 100, and because Medlin is 150, I'm gonna be as honest with you as possible. I'm saying it's at least a one circuit split. Well, at least one circuit is different, but you're correct. I think it's probably two under the rationale expressed in Pine.
We appreciate council assistance this morning, good arguments, and we're going to come down and and Greek council, as we do, as a tradition of the Fourth Circuit, and then we're going to take a short break.
Thank you.
This honorable court will take a brief recess.
All right.
Circuit.
You may be seated. Our third case today is Eddie Stewart versus the GES Recycling, South Carolina. Ms. Sumter?
Yes, Your Honor.
Good to have you with us, Ms. Sumter.
Thank
Nice to see you.
Good to be here. Good morning, may it please the court. I'm Geraldine Sumter, and I represent Eddie Stewart in connection with this matter. First, I want to make clear that the only issue before the court today in this case is whether the district court improperly granted summary judgment on the retaliation issue. The hostile work environment and race discrimination issues are not before the court.
Now, the strongest claim would have been the hostile work environment, wouldn't it have been?
Maybe.
Maybe. But it's time barred, or was ruled to
Yes.
be time barred, and you're
Yes.
not appealing it.
That's correct, Your Honor. Now, in this matter, what we have is an employee who, on June 13th, 2017, was met by a manager who engaged in some offensive, ridiculing, racially offensive behavior. That incident occurred outside on a dock. Later, there was a conversation between the two of them in a break room in the presence of other employees. And as is required, we must take the language and the behavior in the total context of the employment context. We are not talking about an office complex, a school, a university. We're talking about a crude work environment and a recycling plant, where the plaintiff's evidence shows that that kind of language, profanity is often used. Now, after the discussion in the break room, plaintiff gets a call on his cell phone after the supervisor, Adam Gordon, leaves to direct him to come to his office, at which point he tells my client to sit down. Client says, I don't feel like sitting down, and he uses profanity. I'm not trying to minimize that. That's a fact. In the record, my client, in every statement, in his deposition, in his charge to the EEOC, related that he used that profanity. And I
It
think,
wasn't just light-weighted.
I'm sorry?
It wasn't just light-weighted profanity.
Oh, no, it was-
He lit into him real good, didn't he?
Your Honor, is the kind of profanity that for someone of the age group of most people in here would say was just abhorrent. But in today's context, that MF word is used so regularly, even by younger people, in social media, on television, everywhere. Whether that behavior is as severe as it is represented is a question of fact, is what we are.
Is it used when you're speaking to someone who's your supervisor, your boss, or your employer?
Now, Your Honor, I personally would not accept that, but I work in a law office. I'm not out in a construction site or in a recycling plant. And,
Recycling plant, pretty rough place to work. I mean,
of course, Your Honor. Yes.
hard work.
I would suspect so.
I know it's-
I have not done it, but everything
I
that
haven't
I've,
done it either, and I know it's hard, gotta be hard work.
yes.
So, counsel, can I ask a question?
Certainly.
I may be jumping ahead, Tad, so I'm sorry if I'm getting out of the order that you were gonna present it. But, yeah, I've reviewed this a lot, and it would be one thing if Mr. Gordon, terminated your client. But he wasn't the one that, took or carried out the adverse employment action. So, I guess what I'm trying to understand, it sounds like in your pretext argument and even in your direct evidence argument, you have some statements that Mr. Gordon made that are abhorrent. And I don't question them or that they show animus. But does it matter that the individuals who terminated your client were different individuals in terms of the legal issues?
No.
Why is that?
And it doesn't because that animus is imputed to the defendant.
Isn't
In a
that-
case,
Go ahead, ma'am.
All right.
Isn't there requirements for that? Doesn't there have to be evidence that the speaker, the speech that is imputed or the comments that are imputed need to have been made by someone who intended for those to be acted on? Or am I wrong
no,
there?
that's actually the standard.
What's the evidence that Mr. Gordon intended for there to be some sort of adverse employment action?
The evidence is that before even Mr. Stewart was employed, he had made comments to other employees. You have it in the statement of Patrick Denning.
Right.
And you have Mr. Stewart's testimony in his charge to the EEOC and in his deposition, that Gordon said to him, you should stay away from these two because they're talking about discrimination.
Right.
He said that they had been trying to fire those two because of discrimination. One of them was fired, and on June 13th, 2017, Eddie Stewart reminded him that he had told him about those comments and how he did not appreciate people
Right.
making claims about race discrimination. And Eddie Stewart said to him, and that's why you fired Jermaine Phillips. And taking the evidence in the light most favorable to my client, which you must do at this point, Mr. Gordon did not deny that he had said that he would fire somebody who had made complaints of discrimination. What he said was that wasn't the only reason that he was fired. There were other things as well. And Patrick Denning says that when he complained about inappropriate race remarks and behavior in the workplace, Adam Gordon specifically said to him that if he didn't stop talking about that, raising those claims of race discrimination, he would be fired. So taking Mr. Stewart's complaint and his raising concerns about discrimination, and he did in that office on June 13th, when he raised those complaints, we are entitled to have those prior comments and the comments that he made directly to my client when he was hired, or soon after he was hired, used as evidence of his intent to fire people who complained about discrimination. That, I think, is sufficient to bind the company. In this most recent case from this circuit, I'm going to get the name wrong, Wanamaker Amos versus Pura Novi. There was a supervisor manager who years earlier had made some disparaging remark about black people, or it's in, and you know those black people.
Right.
Not close in time to the time that he was recommending that this woman get fired. But the court there said that that past evidence of his animus could be used to show pretext.
Yeah, but I think, if I remember that case, you sound like you've read it more closely, so please correct me if I'm wrong there. My memory of that case was that the person who made that comment was the person who terminated that employee.
It was the person who recommended the termination.
Recommended.
Yes.
And here, as I understand the record, and correct me if I'm wrong, there's not any evidence that Mr. Gordon recommended or was a part of the decision to terminate your client. Am I correct about that?
There is no evidence in the record that Adam Gordon was a decision maker, but the evidence in the record is that Adam Gordon gave evidence about what happened on that day. And so the question is, in a discrimination case, you can prove pretext by showing falsity, and you can, or by direct evidence, circumstantial evidence of falsity. And so the question is, did Mr. Stewart actually threaten Adam Gordon? If you believe what the defense is saying, is that he not only used bad language, but he was threatening and using it, and he had Gordon pinned up against a wall. And that he had used the word, the B word, directed at a female employee. He denies that.
Right.
And so given this history on Adam Gordon's part, and given the fact that in his conversations with Mr. Stewart, Gordon acknowledged and even told him on more than one occasion, that he was not in favor of people raising complaints of discrimination, that is enough to give a jury a question in their minds on whether when Adam Gordon is reporting incidents, that incident on June 17th, whether he in fact was telling the truth about being threatened.
So your argument is, he said before, I don't like, complaints about discrimination. There's witnesses who have said that had a role in other terminations.
Yeah.
On the day that we're focused on here, he reported what happened, in terms of being interviewed, and that, that we should infer from all that he reported in a way that was intended to get him fired?
Yes,
Okay, I understand your argument.
all right.
Thank you.
Certainly. Now, in addition to.
Let me be clear on, make sure I understand that. It sounds like he just went and reported on his own. I thought his conversation or something was being overheard by a supervisor, who then caused it to be further looked into. That's when it came up. But
So-
Mr. Gordon didn't on his own just go up and make the report.
I'm not saying that Gordon went to somebody and said, fire Eddie Stewart. No, that's not what I'm saying. I'm sorry,
Or
the
even
name
that he
escapes me,
reported the
but another
conduct.
person.
He waited, and it was when the supervisor, who I guess oversaw this commotion, wanted to know what it was all about. Is that not the way it happened? I mean,
Well, what happened is, there was a gentleman in an office who testified that he did not see the incident, but he heard some commotion, and when he came out, he then talked to Eddie Stewart and essentially said,
the
I'm trying.
gentleman in the office, was that a superior to Gordon?
I think so.
That's
Don't hold
the
me to
point.
that.
That goes back to where we're going here. That's the person who then took action, and if he went and asked what happened, I don't know if that's a report, or he just asked him what happened and made the decision to then terminate your client.
They claim that there was an investigation and they questioned people. They asked, now, for somebody who was supposed to be so threatening, that it justifies a termination, understand that on that day, that individual, and I'm sorry, name escaped me, that individual told Mr. Stewart to go home for the rest of the day. He didn't call a cop, he didn't do anything like that. And then the next day, they called this man who was supposed to be so threatening to come back to their premises and give them a statement. And he did that. And so the question.
We started out asking about this language, and you did a beautiful job of, I guess, comparing how things are now and how they used to be back in so-called our day. I got that. Or how we would do things. But even with what he did, and just the cold record here, you cannot divorce a feeling, this is not a regular guy with what he's saying and how much he says it, and I don't want to repeat those words in here. Those words themselves are caustic, but you gotta believe he didn't just stand in a corner and gently say them. I mean, it sounds like he was really an aggressive guy.
Well,
And
let
he
me
used some really, really hard language, even by today's standards. I'm not sure there are many individuals that even take that today now, not what he did.
Well, Your Honor, if you and I are going to have to decide whether that was threatening or not, That's a question for a jury, not for a judge.
But whether
And
it's
so-
hostile and insubordinate as the reason for doing it, and this supervisor saw them in this and made a decision, who may have a different level of sensitivity, but say, no, we're not gonna have that here. You've gotta go.
So let me be clear. The supervisor who came out put an affidavit in, and he said that he did not see what happened. He only heard some commotion. So this notion that Adam Gordon was pressed up against the wall and threatened by my client only comes from Gordon and not my client. That, I say, is a genuine issue of material fact, coupled with all of the other evidence that should take this issue to a jury and not be decided on summary judgment. And my red light is on, so I'll be back there.
Thank you.
Thank you, Ms. Sumter. You saved some time for rebuttal.
Yes.
Mr. Pryor?
Yes, Your Honor. May it please the court, my name is Ben Fryer, and I'm here on behalf of the appellee GES Recycling, South Carolina. When I was going to law school down the road in Charlottesville, and I imagine being in an argument like this today, I was not anticipating riddling the record with coarse language and some things that my mother would be embarrassed to hear me say, and I'm glad I probably won't have to do that today. But I think there are a
This
couple.
is language that no one will use in the courtroom. I don't know why.
That's right, Your Honor.
It might be more effective if we did.
It may-
It's okay to say what's in the record. I
You-
mean,
it's in the record.
not you saying it.
Yeah, I don't
You can say the language.
It's actually in it, you're quoting. You're not saying it yourself.
Well, and I think that what you just said, we're quoting. And who are we quoting from? We're quoting from Mr. Stewart. Mr. Stewart wrote.
The language was going both ways.
That's not true, Your Honor.
You don't think?
No, it's not true, Your Honor. And I think it's important to look at the record because Mr. Stewart, there are 3 statements from Mr. Stewart in the record. One is the written statement that he gave GES as part of his investigation. And he admits to calling his supervisor any number of terrible names.
And which supervisor?
That would be Mr. Gordon.
Gordon was direct supervisor.
That's his direct supervisor.
Yeah.
And in Mr.
And
Stewart's
he used the MF word.
MF word, the fat MF word, this is a number of things. What he does not say in that statement anywhere is that Mr. Gordon used any language similar to that whatsoever.
Well, maybe he didn't, but he was used, he may not have been using the same profanity. At least the record may not indicate he was. I think there's some record that it was mutual, but maybe not specific here, so grant you that. But can you push someone with racial comments that are indefensible to the point that if they kind of, for lack of a better word, snap and let loose with some expletives, that you then say, well, yeah, you're insubordinate?
Well, I think there's a couple pieces to that, Your Honor. I think one is about the claim we're here on. If Mr. Stewart's coworkers, as he has alleged, engaged in vile racist comments, I can imagine a person being quite disturbed and pushed by that. Those claims are not here today. The only claim here today, no, I'm sorry, Your Honor, the only claim here today is about this incident on which Mr. Stewart complained to Mr. Gordon. Mr. Stewart admittedly was profane at the least, admittedly caused a disturbance because he says 2 different employees came down. One told him to calm down, to be quiet. Another, the CFO, came down, locked him out.
So it sounds like your answer, and I'm sorry to cut you off, I just don't want to take all my colleagues' time with this, is that, the question I ask may be more relevant to, as Judge King kind of, I think, alluded to earlier, maybe a hostile work environment claim or something else, but we're, for whatever the reason is, we're here on something specific, and, that's what you're focused on.
It is, Your Honor.
You're trying to limit it to the retaliation claim. That's what the claim is, sort of appeal.
That's the only claim, Your Honor.
That's the only claim. But the other evidence that's in the record, to the extent it's relevant background for what you want to get consistent. It's the context.
Sure, but the
We
context,
can look at the context.
Sure.
We're not, we don't have to isolate it
and
to that one instance.
and that's fine, Your Honor, but I think that's fine here because the context is, Mr. Stewart is actually making a complaint to Mr. Gordon about racial discrimination. He has every right to do that. He has absolutely no right to behave himself in the way he did that day. You can make a complaint that is protected activity under that section 1981, which is the statute at issue here. You can make that complaint and it can be in good faith and meritorious. But if you do it while you're kicking the HR department's door down and wielding a knife or something like that, your conduct is not protected. And what we have here is.
What if, though, does it matter if the course of conduct, and I know you're saying that Mr. Gordon the record doesn't show his profanity, but hypothetically, if we do have an environment where, Mr. Gordon and his level and Mr. Stewart and his level, they're cussing like sailors all day long back and forth. Does that matter? I mean, you then, no one's fired him for cussing for the whole time he's been there. And then he, gets fired for insubordination based on, no question about it, language that is, probably not, spoken with the greatest degree of care, but does the environment not matter at all?
No, it certainly matters, and I think it's just what Judge King says, context matters, right? If you are out on the production floor and it is commonplace to curse, if you're cursing about a bad call in a football game and that's allowed, then that's allowed, and that context matters. But this context, what we do not have, there is no evidence that any employee has ever subjected their boss to this kind of language. There's no profane name calling. There's no example of anyone else ever engaging in anything like this.
Now,
That
he
is
wasn't the
different.
big boss, though. He was an intermediate boss. He was the supervisor, but he wasn't enough of a boss to be the decision maker.
That's right, and that's a very good point, Your
Like,
Honor.
he's like the foreman or something like that.
He's more than that.
In the
Your Honor.
Army, maybe the squad leader or.
I would say more like a junior officer perhaps than that, but you're right, he wasn't the decision maker, because what happened here was that because of the disturbance, the CFO came down and asked Mr. Stewart to leave, come back tomorrow, we'll get your statement. He came in, he gave that written statement, it's in the record. Mr. Stewart, to his credit, pulled no punches, he admitted to what he said, and this was an investigation.
But what he said sounds like it was all common language around there all the
Yeah.
time for years before that.
Well, Your Honor, Mr. Stewart does not say that it's
No,
common
he
language.
doesn't say that, but.
He does not say that it was common
That's-
language. There was a former employee that gave a affidavit that said it was common. Even that never says it's appropriate to talk to the supervisor in this manner, or that it had ever happened before.
But it seems like he did it all the time. It wasn't like he did it one time, and when he did it, it didn't seem to make a big difference. I mean, he did it one time and, hey, it's kind of the way it is. The difficulty of this case is, like Ms. Sumter pointed out, she works in a law office, we work in different environments. Even one of these statements would have been enough. It would just not happen. But we all know, and we live in a world where we know there are environments in which that kind of language is said as a matter of course. It's just the way you talk. And so getting back to Judge Qualibon's point is, and maybe the record needs to be developed for that, or maybe we are just not there. If we get into the question of, is this a jury question? In other words, do we allow the record to be developed to say, well, this is an environment that gets close to saying it's a hostile environment? Well, maybe not under their standards, but under objective standards, it certainly looked like one to me. But, the point being is, when we look at the cold record at that language, you can decide this case right away. That looks there, but that's not just what is there. There's something here, and that's the nagging part of this case. There is something else going on here beyond him using that language. And, an individual who would use that language, mostly you would know you ever call your boss that most people would expect, I'm not gonna be here tomorrow. You wouldn't even show up the next day. You know that's not gonna happen. But there's no belief that that's enough to get rid of me in this instance by this individual. It's like, and it sort of points to, this is the culture in which he worked.
But it
And
was.
it may not have been the culture of the supervisor, and that's the problem.
But
If you have the culture being of the workers, but then the supervisor may have a different take on it, and he may, I don't know, he wasn't, I don't know if you heard or whatever, but he lives there, and sometimes people turn a blind eye like they don't hear it.
But the supervisor, those are who matter, right? It's the decision makers who matter, okay?
I'm talking about the supervisor of Gordon, I'm
Sure.
not talking about Gordon.
And I am too, Your Honor, so.
Your point, I think, would be the issue I've kind of pushed and Judge Wynn's pushed is maybe they're in the light most favorable to Mr. Stewart. There's a, environment where he thought he could talk that way. I know you're not agreeing with that, but hypothetically, if that's true, isn't, given the fact that he wasn't the decision maker on the adverse employment situation, there has to be evidence that he did something with the intent of affecting termination?
Yeah, that's exactly right, Your Honor. The investigation was done by two senior leaders at GES, one an HR representative, one an operations manager. They got these statements, and they told Mr. Stewart why he was terminated. And this is Mr. Stewart's words. Mr. Stewart said he was told he was terminated because we understand you have some concerns, but we cannot allow you to talk to your supervisor that way. Full stop. Not that you threatened him, not that you backed him into a corner, not that we credited one story versus yours. Your story that you tell us is that this is how you spoke to your supervisor. And maybe there were some issues, and by the way, the record shows that they were investigated afterwards. Maybe there were some issues, but you cannot talk to your supervisor this way. We cannot run a company this way. And so this notion
What
of
kind of a
whether it's
business
threatening-
really was this? It was called recycling.
It is just that, Your Honor, it's scrap metal.
Up in West Virginia, we used to call them junkyards. Is that something
Yeah,
different?
not completely, it's scrap metal, it's bringing,
metal,
it's
yeah.
bringing these things in from
I
different
mean, it's
places.
like the roughest
But I
place
would,
around, I expect to work.
but I would submit to you, Your Honor, that if we go to those
And
environments.
the big fight, that one of the big arguments they had back and forth, who's gonna run the crane? And whether this Gordon was permitting the plaintiff to be trained to run the crane. That was a prestigious, part of the job, I think.
But
And he didn't get trained. And
but the record is clear on that as well. There were two other African Americans that were trained on the crane and operated it regularly. There was a third that was sent for training and operated it regularly. There was two others that chose not to be trained. And Mr. Gordon told Mr. Stewart, if you want to be trained on the crane, you
No,
have
but
to
just a
come
rough
in.
place to work. And bad language was common. And
But
talking to each other in bad language was common. That's just the way that's just the way they operated.
But there's no evidence that anyone spoke to their supervisors in this manner. And I would submit to you that even if these individuals were using this bad language, if one of them belligerently calls the other a fat MFer, there might be a problem there. It might not be suddenly excusable. But there is no evidence that this is cultural or within any range of appropriateness to talk to your supervisor in this manner. And again, it may be perfectly fine for employees out on a production floor moving scrap metal to use profanity. But when they are speaking in this kind of manner, in an insubordinate manner to their supervisors, it's undermining the ability of the company to function and manage its employees. And that's exactly what the decision makers say here. These decision makers, they don't say they base something on what Mr. Gordon said. They said, we base this on your statement, Mr. Stewart. And maybe you had issues here, and those were investigated, but you cannot speak to your supervisor in this manner. And that's what happened here. And those two individuals were divorced from whatever was going on with Mr. Stewart, Mr. Gordon. Mr. Gordon, there's no evidence that he provided any recommendation on termination. And in point of fact, look at their two statements. Mr. Gordon doesn't even quote a curse word. Mr. Gordon's statement is actually far tamer than Mr. Stewart's statement. And it contains no indication of what he thinks should happen. And in point of fact, Mr. Gordon didn't have any intention to terminate Mr. Stewart. But when Mr. Stewart said, hey, he told the coworker, hey, I'm terminated, Mr. Gordon said, no, you're not. You're suspended for tonight. And that was all he was doing. And he had no role in the termination that proceeded, only after investigation. And our case law shows that therefore cannot be imputed to those decision makers. And so I think that matters immensely, both for the decision, whether it's direct or circumstantial evidence, but I think it also matters immensely for whether Mr. Stewart can prove pretext, whether he can prove that these decision makers' real reason for terminating him was because he complained to Mr. Gordon about racial discrimination. There's just no evidence to suggest that that is a false statement. And unlike many cases that we've seen, and certainly that my esteemed counsel has referenced, there are many cases where an employer says something at the date of termination and then tells a court something very, very different 18 months later. There's never been anything like this here. The individuals who informed Mr. Stewart of his termination told him exactly why. It was based on his admitted misconduct in how he spoke to his supervisor. And that's never changed at any time to this day.
Well,
And so there's no question about.
There's an indication here in the record that Mr. Gordon didn't think much of people complaining about discrimination. He told the plaintiff, when he started, that he should stay away or not hang with two specific African-American drivers because, quote, they complain about discrimination. So
And
he
if-
was sensitive to the black workers complaining about discrimination.
And if that were true, that he said that, which we can assume for the purposes of summary
Don't we have
judgment
to,
motion.
don't we have to accept that?
That's right.
That's true for
Yep.
purposes of our review.
Very good point, Your Honor.
That's a point.
Yep,
I mean,
very-
that's,
very good
that's a
point.
fact for purposes of our review.
That's true. So we accept that as
So
true.
you have to get past that.
But here's
and
how
to-
we do, Your
to-
Honor.
To convince us that
Sure.
his termination
Right. And the way we get
was
past that
not
is
impacted
because,
by that kind of thing.
yeah, if Mr.
So
Gordon.
he already had that preconceived notion.
And if Mr. Gordon had been the one who terminated Mr. Stewart, then Mr. Stewart probably would have survived summary judgment at the district court. But Mr. Gordon's not. And there's no evidence of any kind that Mr. Gordon had any role in the termination decision or that he contributed any false information or biased information to the decision makers. There's no evidence of that whatsoever. And so, assuming that what Mr. Gordon said, is alleged to have said, is completely true, it matters not here because he's not the decision maker and he didn't do anything to contribute to this decision being made. This decision was based on the admitted misconduct by Mr. Stewart that he freely told GES as part of his investigation. And the decision was made by two individuals in management and HR positions that had nothing to do with Mr. Gordon. And I will just say, Your Honor, there's background here that may have been a cause of action of other types at some point in time. And the lower court found that those were either not sufficient on the merits, or they were time barred, and they haven't been appealed here. Those were other.
That's the reason I made my remark earlier that there was a hostile work environment
There could have been.
on this evidence.
There could have been, and that may have been an alternative avenue that the law allows for.
But this is not a hostile work environment claim, it's a retaliation claim.
That's right, Your Honor. And I will cede my minute or so unless there's questions.
Thank you very much.
Yeah, thank you, Your Honor.
Ms. Sumter?
Thank you, Your Honor, just briefly. In a retaliation case, Supreme Court has told us that the plaintiff's burden is to prove that, but for the fact that he or she engaged in protected activity, a decision and adverse action would not have occurred. Now, but for does not mean that that's the only reason. We have seen from the Supreme Court in Judge Gorsuch's opinion in Bostock that but for doesn't mean the only reason. And so in a case where you have a retaliatory animus so clearly stated by a manager who reports to the CFO and others who were making the decision, I think that it is appropriate for you to take into consideration that animus and impute that animus to the other folk who were involved. This court just recently did that in the Wanamaker-Amos case. In addition, on a retaliation case where there has been a showing of some animus, it is not necessary for the plaintiff to show comparator evidence. This isn't a straight discrimination case, it's a retaliation case. And the plaintiff doesn't have to go around and show how every other person in the work environment who used this kind of language was treated. But what the plaintiff has shown to you is that while the MF word is a bad word, that there were other equally offensive comments of a racial nature which never resulted in anybody being disciplined, less more terminated for. And so if offensiveness alone is a criteria or a consideration and determination, then we would say, yes, look at that information. Now, this question, and I know it is on your minds, can an employee, can you say to employers that you have to allow an employee to talk to supervisors any kind of way? That is really not what I am suggesting to you. What I am suggesting to you is that where the company says, just because you use this language to your supervisor, we are going to terminate you, becomes a question of fact when there is evidence of retaliatory animus in that process. And for that reason, this case should go to a jury. Thank you.
Thank you very much, Ms. Sumter. We're going to adjourn court for the week. Come down Greek Council and wish everyone the best.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.